This next thing we're going to talk about are contract essentials for small business owners that are related to clients and retailers. So that means anyone who's going to buy a product or service from you. What types of contracts, Aron, do we need to have in place to protect ourselves?
So looking downstream, going back to what we talked about at the beginning, you've got the internally focused ones with the employment agreements and independent contractor agreements. The upstream ones are what we just talked about. So now we're looking downstream. Who's buying our stuff? For that, you're going to be looking at really service agreements or some variation of those, some sort of purchase agreements, or so if they're just flat out just buying stuff and that's it, if it's just they're buying 100 of your widgets, you may not need that complex of a relationship with them. It's just they're going to need to pay you for that stuff. But if it's a little more complex, if there's some sort of consulting angle, or if you feel like there is a threat of them taking your intellectual property because maybe you're selling them something that is new and you designed it yourself, then you may want some sort of service agreement in place. With that service agreement, you can put the intellectual property protections we talked about, but also I would put in there some sort of payment terms as well as liability. So for example, if you're selling a product that could be dangerous, you want to make sure it's really clear who's got the liability for what and when, and probably the retailer. I mean, the default law, and I haven't brushed up on this today, but I believe the default is generally retailers aren't going to be held liable for something that's dangerous unless they messed with it. So for example, if you buy a lawnmower at Home Depot and it ends up killing somebody, you probably can't sue Home Depot unless Home Depot manufactured it. Now, I would want to double check that, but I believe that's the case. Basically, retailers are generally not going to want to take on any additional liability. But one thing that would be important, in maybe a service context, is disclaiming what you're not doing. So, for example, in my engagement letters, I put, I'm not providing tax advice. Because we may talk on things that deal with tax issues as a business attorney. So I'm not providing tax advice. I'm not providing business valuations because I deal in mergers and acquisitions. So you might want some things that disclaim what you are providing, saying, okay, here's what you're buying from me, but here's also what you're not buying from me. You cannot rely on me to provide X and Y and Z. And then in terms of what your remedies are within those agreements, you may want to put some things that give you some leverage in case they don't pay. So generally, the ways that you can try to go after people, there's a couple of ways. One, you hold their product if they're not paying you. So require payment in advance. Don't bend, don't break on that. Like, get them to pay you so that you send your stuff. If they're not paying you now, what motivation are they going to have to pay you later? And what leverage are you going to have to force them to pay later? If they're running out of money, and they don't have the money to pay you now, to me that's a red flag. Don't send them the stuff. So hold their product. Another one is put a lien on stuff. So liens, the typical situation that any homeowner might run into is you have somebody to come do contract work on your house, like your air conditioning, or they pour a new driveway or something. And then if you don't pay them, they can put a lien on your house. So that's, and a lien, to explain that as a legal concept, is basically something they go file in the public records. And then when your house sells in that situation, then the proceeds of the house, they get some of the proceeds automatically because of their lien. And so it's an impediment to selling the house generally, because before I sell the house, some buyer that comes along will say, we see there's a lien on your house. You need to pay that off first so that there's nobody else coming after us, and then we'll buy the house from you. So in the same way, you might be able to put a lien on products of various kinds. So there could be language in the contract, if you do have an ongoing relationship where you may send stuff before it gets paid for, that you have a lien on any inventory that has not been sold yet by them to secure payment by them. So basically, then you can come back and reclaim that product.
Right.
That would
This works with smaller businesses. So that'd be like when you're doing wholesale, you can confiscate. If you are an M&M manufacturer, but it's keto M&Ms, you can confiscate your inventory and,
Yep.
or, just report the particular owner. It doesn't work with Target, this particular one. But so do you want to tell the next one, the next two?
You mean suing them and reporting them? So suing them, ultimately, you're going to look at what makes sense, from a dollars and cents perspective. If it's going to take tens and thousands of dollars to sue them, and it probably will, then you don't want to go after them if it's only a $5,000 amount of product. So you're just going to need to decide kind of where the threshold is for you there. In many states, there's some version of small claims court. So if you're a much smaller business and you're below that threshold, that's something to consider, because you can usually go to small claims court. At least in Texas, I recommend this to people regularly. Hey, go to small claims court without me. You don't need an attorney. It's kind of like if you ever watched the show Judge Judy. It's just you show up, have your documentation ready, have any witnesses with you that you might need to call, and just present the case the best you can. So that could be a way to go. And then, if they're not doing anything else, then use third-party reporting mechanisms. So if you can report them for not paying to credit agencies to the degree that may be applicable, leave reviews, basically create leverage out in the industry by, working against their goodwill. Don't say anything that's not true, but because then you open yourself up to a defamation claim. But make sure, you just use the leverage that you have, and if you think it's going to be useful at that point. And I'd say that's probably a last resort, because at that point you're going to be souring the relationship. But if
right, and you probably won't get paid. It's really more about warning other people to watch out at that point.
Yeah.
Yeah. So, this is such a juicy topic because I personally have run a business for such a long time, and I learned it the hard way. There was one company who called me on the phone, and he had already paid for a number of different products before. So, but it was always slow. It was always a big pain to chase him down and get paid for orders. And we used to have terms like 50% upfront, 50% deposit at the end. And so this particular person called one day and said, "Oh my God, I have the biggest order in the entire world. You have to air freight all of the samples because this person needs it by this date. It's Christmas coming. I need to have this last minute order." And I told him, "Okay, this is a lot of money. Do you realize air freight is 5 times as expensive as ocean freight?" So I was worried, and I went and got an estimate, and I sent it to him, and it was like $25,000 for the freight, plus something like $30,000 or $40,000 for the product. And I said, "Are you sure? Are you sure?" And he's like, "Yes, I'll do it." And I said, "Can you please pay?" At that time, I don't think I had terms to pay for freight up front. And so we initiated the contract. We had a signature saying, "I will pay it," signing off the estimate. We shipped it. We we kept calling him to get some payment, and he hadn't done it yet. And at that point, it was like the holidays. One of the employees that was supposed to be watching it didn't hold the product. And even if they had, we would have been sideways holding it because we'd have to pay a holding fee. So we delivered it and never paid for the product. And to this day, I still see, the samples that we created in his stores. And after 2 years of time, so he made small payments, but I still ended up having to write off $40,000 or $30,000 of debt because I didn't have to pay it up front. And so now I never let anybody, no one can buy from me except for upfront, especially because it's all custom stuff. With a packaging company, I can't resell it to someone else. If you're watching this and you're a brand owner, you have a little bit more recourse because you can make the candles and not deliver them or something to that effect. But these pieces of advice that Aron just gave is very, very valuable to anyone listening. If you don't, so just to repeat for anyone who's here, he said in your invoice, make sure that you have an invoice where you're going to invoice the client stating the terms. That's an accounting based thing that's issued from your QuickBooks, but you also should initiate a service agreement. And this is especially applicable for anyone watching who sells wholesale. So if you own a brand and you are selling wholesale, you are selling to small businesses or to distributors, and you need to clarify for them the payment terms. So an example of a payment term applicable, your cash flow is the most important, powerful thing to keeping your business afloat. And so you can either request for payment upfront, 100%, because you're not really in the business of giving credit when you're small. So that's a great idea, as well as doing, if you are dealing with larger retailers will not pay upfront, but you can give them payment terms that reward them from earlier payment. So you could say, here's your price. We give 1% off for net 10. Meaning if you pay within 10 days, we will give you 1% off, or, you can give as much as 3% off, whatever it is that's going to really motivate you. And you need to not just put it in your invoice. You need to actually have a conversation with your buyer to clarify this, because this is about relationship. I've seen some retailers like Target. I know it wasn't Target. I don't know what retailer it is, and I probably shouldn't say it even if I did, but what they did is they saw this invoice that said, oh, we get 3% off for early payment. And they took the 3%, but didn't do the early payment. So, and there was such a big company, you couldn't get the money back. What are you going to do? Sit on the phone with their accounts payable department to argue over a few $1,000s? It never happened. So
I would.
Oh, you would. That's because Aaron's a good attorney right here. Aaron's a good attorney. So anyone who's watching, we're talking about client and retailer relationships and the contracts you need to have in place. And so right now, what we just said is that invoices need to exist, but so do service agreements. And in those service agreements, you should pre-talk about the terms of payment. So you got to pay me up front, or you have to pay within 30 days, or there's a fee. You need to talk about the process of collections, like how you're going to handle getting paid. Oh boy, overages and underages. So what will happen if they order 1,000 units, but your case pack includes 6 units. So you have to ship a little bit extra. You're going to charge them extra. So you might send them a revised invoice. Their purchase order might say 1,000 units. You'll send back an invoice for 1,006 units or whatever it is. Lead times for delivery. And you also want to talk about any other process for how you're getting them set up. So when it's wholesale, hey, it takes us 3 weeks before you can get your first purchase order. So that's what you would include in the service agreement per Aaron. And then you want to repeat some of those terms in your invoice, which is the accounting statement. And then the other thing that Aaron just talked about was getting paid when people, when they don't pay. You might want to even specify this in your services agreement with process collections, but you can hold their product. We recommend, go ahead.
You can also have terms related to late charges, interest that gets charged after a certain point. So you can have an initial late charge if they don't pay within X amount of time, and then interest that starts accruing on outstanding amounts due, because you're not in the business of providing free credit. So if they're going to just take free money, then they need to be charged some interest on that. So that's another motivator potentially. Although usually businesses, if they get to that point where they're that far behind, they're either in trouble or they're just very risk tolerant is maybe a tactful way to say it. But it's not uncommon, I would say, in those situations, even when you have those terms where they eventually call 6 months later and say, okay, we'll pay it. And they don't end up paying the interest, and at that point, you're usually just happy to get the payment. I think the best way to make sure you get paid is to be proactive on the front end.
Yes, and even you can have different terms. If you're listening to this, you can have different terms when a client first starts to work with you. And so, because what I've found is that the type of client who's hard to get them to pay upfront or hard to get a hold of to pay afterwards, they will be like that for the entire business relationship.
Yes.
People who pay immediately, man, I love those people. First of all, they're like my favorite clients. You want to bless them, because if they're going to bless you by giving you money, you got to make sure they're your top priority client. But in terms of people who are your vendors or clients who are currently paying you well in the beginning of your relationship, you can expect that for the most part, they're going to stay pretty consistent. So you can have different terms that are related to someone in the beginning of your relationship, and after a certain amount of time of consistent payments, you can give them a little bit more credit. So
also, if they come back to you, that's a good point in time to apply leverage. So if they were late last time and they didn't pay the late charge and they didn't pay the interest, and they have a something that's on fire, you can say, well, you still have this amount that's outstanding. So once you take care of that, I'd be happy to help you. I have a story about that happened for an attorney. They got stiffed thousands of dollars by this client, and this client couldn't find anybody in town to take on this lawsuit, came back to this attorney, and the attorney said, okay, so you're going to need to pay the outstanding invoice, and you're going to need to pay this huge retainer. And you also need to put this other huge bonus in escrow, because if I win this case, I want a bonus just because I won. And unless you're willing to do all that, I'm not taking your case on. And so the guy had to pay it because no one else in town would take his case.
Right. And that's where Aaron, I love what you're saying here, because we're talking about a pound of, what do they say? It's a pound of
an ounce of prevention is worth a pound of cure.
So as a small business owner, it's risk mitigation. These contracts are about risk mitigation. And it's important for having a clear relationship with your client and vendor, so that if anything goes wrong, you can protect yourself. But also, it's just great to talk to them about these things. Every client is different. Trader Joe's pays on time. They always pay on time. They're a consistent, incredible company if you can get into your products in there for that reason. When it comes to payments, other companies consistently pay late. And so you need to get to know your accounts payable team, ask them questions when you're getting set up. And the more you know about them, the more you can mitigate your own risk. And the one other thing I want to throw out there for anyone watching, I do realize that when you're working with bigger companies like Target and Walmart, you don't get to have a service agreement. I mean, you can send one to your factory or to your retail buyer, or you can tell them what your terms are and send it to them and ask them to sign it. But their legal team is so much bigger than yours. And they already have a service agreement. They're going to tell you how they're going to do business. And you should call someone before you get into Walmart, call somebody who's sold to Walmart and ask them. Because oftentimes what you have to do is give them pricing before you see the contract, because they want to review, should I buy from this guy? And then they'll set you up as a vendor. What that means to you is that you don't even know they're going to charge you fees. So you sent them pricing, assuming that they're going to operate the way that other wholesale accounts work. And then you realize only after you sign the contract that, they're going to charge you a fee if there's spoilage, or you have to pay a slotting fee, which is $1,500. Well, there goes your margin on your first order. So you should call someone to ask what the service agreements are like and the payment terms are like for any big companies, big companies, because they can flatline you as a small emerging brand if you don't understand those things. So go call someone. And the second thing is they will give you a service agreement that is going to be way outside your scope. So have an attorney read it.
Yeah.
Have your accountant read it. Have multiple eyes on that thing. I
can't tell you how many people have come to me or my office, and they've already signed the large agreement, the 50-page, the 75-page document. They started a franchise. They got into business with a larger company, something, and they didn't get legal help on the front end. And now the relationship's gone south. Now their business is dying. Now the other side is applying pressure to them. And basically, at that point, I'm like, I'm sorry, I can't help you that much to negotiate this. All I can do is point out to you what your rights and duties are under here and tell you what you're supposed to be doing. But if there's not an out, sometimes there isn't, then they're stuck in that relationship. Like, in the case of franchise owners, that happens sometimes. They are then stuck owning a franchise and they literally can't get out of it. And it's a terrible situation.
That's really, really poignant. And I think the important thing for anyone watching is there is so much enthusiasm when you first get an offer from Costco, Walmart, Target, the bigger the retailer. You're really excited. You're so excited. You want to do anything to get in there. And in your mind, you're like, this is what I've been dreaming about. Most retailers or brand owners that I talk to, when they call me for consulting advice, how do I grow my business? They tell me, I'm going to one day be in Target. That's my goal. So they're fixated on being in Target, but they don't have the addendum to the sentence, which is, and be profitable. Get on the store shelf and stay on the store shelf. Get on the store shelf and continue to sell. And so if you don't review your contract before you sign it, the pricing that you give them or getting into Target too early in the evolution of your company could crush you because you don't have the processes in place. You're not ready to fulfill your service agreement. And imagine this world. Okay, we're talking about the worst case scenario where a company doesn't pay you. It's unlikely that Walmart won't pay you. They might just pay you on their own time. But a worse situation is you sign a service agreement that requires a purchase delivery, for example, on a purchase order within 2 weeks. This is a typical thing that happens in a service agreement. The retail buyer is used to working with large companies. You're a small company. You've never made large enough orders to fulfill to Walmart. So they order one full truckload, and for some reason, there's a supply chain issue. You can't get the glass for your candles. And so you owe this purchase order within 2 weeks. All of your team is hustling. You can't get the glass. You're working 3 shifts a day, and you miss the delivery date. You know what your buyer is experiencing? They have shelves that were dedicated to your product, and there's nothing on them. And what does their boss say to that retail buyer? You idiot. You bought some product. You took a risk on a vendor who doesn't have a good system in place to be able to fulfill your purchase order. You idiot. So that's the boss talking to the retail buyer. So how do you think they feel about you when they're up for review and their bonus and they didn't make their sales quota for the month?
Not happy.
Oh, so unhappy. So you, business and brand owner who's watching this right now, this is another reason why you need to not only have an attorney read this contract, but an accountant or a business growth consultant, because you just need multiple tiers of advice to protect you. Yes, you want to get into Target. Yes, you want to get into Costco, but not before it's the right time. Not before you can do it in a safe, productive, happy way where you can fulfill the requirements of a service agreement with them. Don't accept and sign a service agreement until you understand the consequences of it, because if you mess this one time up, you will never get in there again. They will not forget that you screwed them.
Yeah.
So
to steal to analogize to a different situation, one of my favorite pastors has a phrase related to promotion. And he says premature promotion, before you've laid the foundation with your character, will destroy you. So in the same way with a business, overly aggressive growth or expansion before you've laid that foundation will destroy your business.
I love that you took it from a super practical thing to even like a higher level macro piece. And this is again why I appreciate talking to you, Aron, because you have business in mind, but you also have like that internal compass. And for anyone else watching, I would agree with that. Life, we can get so fixated on the outcome of growing your business, becoming a multimillionaire. Everyone wants to work remotely and have passive income. This is our lingo of our culture right now for any business owner. But at the same time, dude, it's about the journey. It's about who you're going to become in the process, who your business is going to become in the process. So if you are watching this and you own a small business, what we are basically saying is that contracts need to exist. And the reason why you need to implement contracts is because you need to have healthy relationships. You want to have healthy relationships with your employees and contractors. You want to have healthy relationships with your factories and vendors, and you want to have healthy relationships with clients and retailers. We want to have integrity internally, and we want them to have integrity. And sometimes 2 people can have a ton of integrity, but not understand the terms of what the other person is expecting. So an effective and good legal contract is going to itemize those things, clarify what does it look like from both sides, what are the expectations. And so you need to have contracts in place. To close out this particular topic of clients and retailers, Aron, can you just help again answer that question? When is it okay to make a service agreement or accept the one that they're giving to us, or maybe buy one on LegalZoom? And when should you have an attorney craft a brand new one, or maybe even read it? And what's the terms of that? Like how hard or expensive would that be? Should we have someone on retainer? Explain the terms of having an attorney help us with this.
Yeah. So I'd say on this piece, also not doing it on LegalZoom, because it's just not the kind of contract where I would trust. And I know we've knocked on LegalZoom a bit, but LegalZoom, I think Rocket Lawyer, there's a couple others. If you scroll down and look at their terms and conditions, just to give you a couple of things about them, They explicitly disclaim any attorney-client relationship. So they're not actually providing legal advice. They're basically TurboTax for lawyers. It's self-help. It's do-it-yourself, which I understand is the attraction, but you get what you pay for. And they explicitly disclaim, for example, that the things that they're giving you will actually do what you want them to do. So they're literally disclaiming the very product they're providing in their disclaimers. So they're like, here's these contracts. We hope they do what you want them to do, but we are not guaranteeing that in any way, shape, or form. So with service agreements, I think getting an attorney to draft it for you or review it for you is important. And in terms of when to have a brand new one versus when to just review what they've got, I think you just have to look at where you're at in your company's growth stage. If you're just starting out, you probably don't have a lot of leverage. You're going to have to take what they give you. If you've gotten to a size where you feel like it would be useful and you're negotiating this on a somewhat regular basis, at that point, it might be useful to have an attorney draft one for you as kind of your company's template. And so I think as you grow, you get that in place. It's definitely cheaper to take theirs and negotiate it than to draft one from scratch. In terms of cost, you're probably going to be looking at anywhere from $1,000 to several $1,000s, and depending on the size and complexity of it, it could be $5,000 or $10,000. And so it just depends on what we're looking at and the scope of that.
Oops. Well, and to add to that, I think what I was going to say is that I think when you have when you're getting into target, that is when you have an attorney look at it 100%. And you also should have an accountant look at it, because you need to understand what these fees could possibly mean for you. That's really important. So in the case of a very large retailer, they will have a service agreement, have an attorney look at it. That shouldn't take longer than, they can tell you based on how long it is, how long it would take. And then when it comes to drafting your own contract, if you are doing wholesale, of course, you need to have a template. You should have something, in place. And so you can even do, this is what I've done with my attorneys moving forward, especially if you don't have an attorney yet and you don't know the personality of your attorney. You don't know, are they going to give you a 100-page thing? That what I've typically done is I've written out kind of like a memo of understanding and saying, like, this is what I think I need to have included in the contract. Like I started a business. I started a ready-to-drink beverage company. And with that person, he was so much more successful and rich than me. I wanted to be sure that before I paid an attorney to make the contract, that I knew between me and the partner what we were going to agree to. And then I wanted to send that to the attorney so he didn't add crazy things into it, or so that he could advise me on what else should be added. So write out a memo of understanding for yourself. This is what I'd like to have included in my service agreement contract with my wholesale clients. And then send it to your attorney, and that will make your process even more affordable. But also, you'll both be on the same page, so you don't hire the wrong attorney. You'll hear as he or she is advising you exactly where their heart and mind is at, and that will be the sign. Oh, this is the guy I want to work with. He's giving me great advice. Then he can give you an accurate quote because he'll understand the scope, and that's, I think, the best way to go about it. Would you agree, Aron?
Yeah, I think that's definitely a great way to go about it, because you want to make sure your attorney is giving you something that's going to be useful for you. No attorney wants to crank out a huge contract only to be told this is useless. So I think making sure you're on the same page. Now, sometimes you may think this needs to just be 1 or 2 pages, and that's just not possible. So understanding what's realistic, because there are certain terms that need to be in there. But yeah, I think trying to make sure you're on the same page with the other person, and then giving those kind of cliff notes, if you will, to your attorney is important.